Hi everyone, my name is Christina, and today I will be briefly going over my example of a contract dispute. And in this case, it is an issue with a couple that paid a deposit for their wedding in July 2020, and then they decided they wanted to cancel it and tried to get their money back, but the wedding venue would not give them their money back due to a clause in the contract that both parties signed stating that all deposits were not refundable. So this would be an instance if the couple decided to sue, probably be a breach of contract case. So let's go over really quick the elements of a breach of contract case. So according to this website, breach of contract, elements in a breach of contract action, the plaintiff is responsible for proving one, the existence of an enforceable contract. An enforceable contract, the example of the contract that the party signed is in the video that I embedded in this post. So yes, there is an existence of an enforceable contract. And then two, non-performance amounting to a breach of the contract. So the couple would probably try to sue the wedding venue saying that there was a breach in contract, they kept their money, but they didn't want to get married there. But again, I go back to the clause in the contract that says that all the deposits are not refundable. And then three, damages caused by the breach of contract. So that would be the money that the Roberts lost. And then this information is cited by case Bancorp South Bank versus Hatchell. Okay, also let's go over the Tennessee law or statute, I'm sorry, that governs contracts to be enforced as written. Section A says all contracts, including but not limited to notes, security agreements, deeds of trust, and installment sales contracts in writing and signed by the party to be bound, including endorsements thereon, shall be prima facie evidence that the contract contains the true intention of the parties and shall be enforced as written, provided that nothing herein shall limit the right of any party to contest the agreement on the basis it was procured by fraud or limit the right of any party to assert any other rights or defense provided by common law or statutory law in regard to contracts. So kind of lengthy, but really important part is and shall be enforced as written. So this just governs that contracts that are not procured by fraud or limiting the right of any parties to assert their rights shall then be enforced as written. And there is no evidence in the video that the contract that the Roberts signed was fraudulent or in any way not allowing them to assert their rights. So this governs the enforceability of the contract, which is super important for the case. And then also there was a force majeure clause in the contract, which is really important, especially governing or with a contract about an event happening and then like there's the pandemic and then all the restrictions. So a force majeure clause and understanding a force majeure clause is really important. So the Tennessee Bar Association states that force majeure generally refers to the excusing of performance under contracts because of either acts of God or human events beyond a party's control. In the United States, force majeure can be asserted either as an affirmative defense to breach of contract or by a preemptive declaratory judgment action. So it's really important to note what that force majeure clause means in the contract. And so let's also move on to case law. So this Court of Appeals case happened in Nashville, and I am using part of it that part of the opinion that states the rights and obligations of contracting parties are governed by their written agreements. So the obligations of the Roberts were to pay the money, and when they signed the contract, they knew, according to the contract, that the deposit was not refundable, which is super important. And then also the courts must interpret these contracts as written, which, as we just stated or saw in this code, contracts are being enforced as written, governs that. And also states we are not at liberty to make a new contract for parties who have spoken for themselves, nor are we at liberty to relieve parties from their contractual obligations simply because these obligations later prove to be burdensome or unwise. So the Roberts entered into a contract that very clearly stated that they would not be able to get their money back, not due to anything really. And so they went into that contract obligation knowing what was expected of them and what would happen if they tried to cancel, as they have a very strict cancellation policy. And again, this news article does not state that the couple tried to sue the wedding venue, and they actually ended up being able to work it out with them and secure a new date. But those are the relevant statutes and case law and just general definitions for this contract dispute. Thank you so much.